All right, thanks. So your programs promise a roundtable discussion of impeachment, and I'm noticing no roundtable or discussants. So my plan is that the roundtable should be all of us, and that's appropriate since impeachment is a political thing, and so my views shouldn't be privileged over anybody else's views. They're all equally valid and relevant. So I guess what I'd like to do is I'll just provide kind of an overview of what the Constitution says about impeachment, what the general process is, and then we all can dive into our roundtable discussion. Before I do that, I think I really probably ought to point out that ACS is a 501c3 organization. It does not advocate candidates for election or defeat, nor does it engage in political advocacy. And anything I might say that tends toward one of those ends is me speaking for me and not for ACS. Okay? So you are hereby inoculated. All right, so the Constitution says that the President, Vice President, and all civil officers shall be removed upon impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. The Constitution then provides that the sole power of impeachment resides in the House, the sole power to try impeachments resides in the Senate. The Constitution says nothing more about how the House should deploy its impeachment power. With respect to the Senate, it says that when the Senate is trying an impeachment, senators shall be on oath or affirmation. When the President is the subject of the trial, the Chief Justice shall preside. That conviction requires a vote of 2/3 of all members present. And then finally, the Constitution says that the punishment for impeachment shall not extend beyond removal from office and disqualification to hold any office of honor, trust, or profit. That is the entirety of what the Constitution says about impeachment. And so it should be clear from that this is not a process of law, right? It's not a process that is driven by legal definitions, by elements of crimes, by all of those sorts of things we learn about in law school, right? Instead, what drives impeachment is, well, we have to start at the end to understand, right? What drives impeachment is the requirement of a 2/3 vote to convict. So the framers did not mean to set forth a finely codified procedure. Instead, they set up this political procedure, and that could be abused. Right? The check against abuse is not fine legal definitions, but rather is the requirement that in order for the impeachment to have any kind of actual effect in the world, there has to be a 2/3 vote to convict in the Senate. And what does that end up meaning? What that ends up meaning is the Senate has to be convinced to sort of a bipartisan supermajority, right? It has to be that the impeachment is being based on something that people of all political persuasions can agree is a legitimate grounds for impeachment, that the facts establish that maintaining the officer in office is simply unacceptable. So that's the constitutional process. And what that ends up meaning is that every bit of the process needs to be run with an eye toward that 2/3 vote, and with an eye towards relying on arguments that proceed from commitments that all hold, right? That are bipartisan commitments, that are American commitments, rather than Democratic or Republican commitments, right? And if the impeachment process is run in that manner, it can be effective. If it's not run in that manner, and again, it doesn't have to be, the House can do whatever it wants. The Constitution allows that. But if the House just does whatever it wants, it will not be effective. Right. And to illustrate that, we can just think about a couple of examples. Right? The impeachment of Richard Nixon was successful. not in the formal sense that Richard Nixon was tried and convicted, but rather it was so successful that even Richard Nixon knew that that was going to be the outcome, and so rather than suffering that fate, he simply resigned from office. The reason it became clear to Richard Nixon that he would be impeached, convicted, and removed is that the impeachment proceeded along the lines that the Constitution contemplates, right? Along the lines of demonstrating that Richard Nixon had engaged in the kind of wrongdoing that is simply unacceptable, right? That made him being president of the United States such a harm and a threat to the Republic that any fair-minded person could see it. Contrast that with the Clinton impeachment. Right, the Clinton impeachment was a partisan affair from the beginning. It was run in a partisan manner, it was rammed through the House in a partisan manner, and it went to the Senate as a partisan manner. Now, actually, when it went to the Senate, I was a young law professor at the time, but then Senator Joe Biden hired me to be his counsel during the impeachment. And when I arrived for the first day on the job, I was really very surprised to meet with Senator Biden and find out that he was actually open-minded. He was willing to be persuaded that, in fact, he should vote to convict the president. I just assumed, Democrats would sort of link arms and all be opposed to the impeachment, right? And I don't mean to suggest that they don't have partisan commitments, but he was open-minded, right? Had the House come and presented their prosecution in a manner that would appeal to sort of good government commitments, I think open-minded senators could have been persuaded. Instead, the House managers presented a highly partisan argument for the president's impeachment, and fair-minded Republican senators voted to acquit rather than to convict. So to the extent you had party crossing, and you did, the party crossing was all Republican senators voting to acquit Bill Clinton, right? And so the essential of impeachment is this sort of nonpartisanship, right? That the appeals need to be made to commitments that we all hold. All right, so that's what we need to consider at kind of every step along the process. Now, as I mentioned, the Constitution doesn't in any way define the House's process. Neither do the rules of the House, right? So the way things proceed generally is you have an inquiry, then you have articles of impeachment, then you appoint House managers and send the thing over to the Senate. Now, first, the inquiry. Again, there's no definition in the Constitution. There's no definition in the rules of the House of Representatives. The inquiry can proceed on, well, whatever basis the House wants it to. It doesn't even have to be called an impeachment inquiry. Now, Nancy Pelosi recently decided to call the inquiry an inquiry, or I should say the inquiries, right? Because there are 3 different committees that are running inquiries into various sorts of misconduct by this president. And is there any legal significance to that designation? Well, there shouldn't be, but there is. The significance is, we talked some yesterday on the rule of law panel about fights over information, right? And so the president wants to stonewall, not hand over information. The House demands information. Eventually, these controversies go to court. And what the court does is to balance, right? It balances, on the one hand, the president's interest in confidentiality. On the other hand, it balances the House's interest in receiving whatever information it's requested. And some of the recent cases indicate that at least some judges think that if the House says the words impeachment, right, or impeachment inquiry, that makes their impeachment interest real, and so we can put that on the side of the scale for the balancing test in favor of the House. Given that any inquiry could unearth wrongdoing that could lead to impeachment, it strikes me that even if the House doesn't say the magic word impeachment, that's always there lurking at the core of any inquiry it undertakes, and it shouldn't matter whether they sort of invoke the magic word impeachment. But some judges like to hear the invocation, and now it's been made. So we have these inquiries, and it seems virtually certain that at some point they will yield articles. Right, articles of impeachment. What will those articles of impeachment identify? Well, mostly I want to leave that to the discussion, our roundtable discussion. The one thing, though, I would point out, again, going back to the sort of essential observation about impeachment, is whatever goes into those articles ought to be something that a bipartisan group can agree are valid grounds for impeachment, right? So on this, I would say, I think the Mueller reports offer or the Mueller report, both volumes of the Mueller report, offer ample grounds for impeachment. But that argument is gone, right? There is not a 2/3 bipartisan consensus around that, and continuing to bring that up just taints the whole inquiry. Okay? So in putting together articles, it's important not just to identify conduct that somebody might think is a high crime or misdemeanor, but rather to identify conduct that we think there's a real reason to believe a bipartisan group, 2/3 of the Senate, can agree represent high crimes or misdemeanors. Okay? Then the last element of the House's process is the appointment of House managers. And this is something that hasn't gotten much attention or much discussion, which is why I want to spend a little bit of time saying a few words about it. Right, so that's the last thing the House does. It appoints managers, and managers are members of the House of Representatives who literally carry the articles of impeachment to the Senate and present those articles of impeachment at the bar of the Senate. The House managers then act as prosecutors at the subsequent impeachment trial in the Senate. Now, the composition of that body of House managers is important in a couple of ways. Successful impeachments, right, there have been 8 of them, right, at least successful in the sense that they've yielded a conviction in the Senate. Virtually every one has been carried by a bipartisan group of House managers. When the group of House managers has been entirely of one party, that would be the Clinton impeachment, well, we know what happened there, right? It taints the presentation. And so right now, somebody ought to be sitting outside of Justin Amash's office waiting to beg him to be a House manager when the time of articles come. Because if you can put together a bipartisan group of House managers, that will allow for the kind of presentation that might be able to build a 2/3 consensus in the Senate. Okay? Now, the other thing about the composition of managers is it includes, or I should say, the prosecution team can include more than just members of the House of Representatives. They can hire outside counsel. Now, that cuts against every political instinct of members of the House of Representatives, because this is going to be a chance to get on national television with, I mean, I guess C-SPAN's national television, but I mean national television with an actual, an actual audience, right, that you can, a measurable audience. Right, they're all going to be dying for that publicity, right? Lindsey Graham was one of the House managers of the Clinton impeachment, and while that didn't turn out well, if you're from South Carolina, it did, right? And so that's how he got to be a senator. Members of the House are going to see this as their time to shine, right? And so that's going to be a strong impulse, and the House leadership is going to have to push back against that. Right, is going to have to say, look, we want to do this in a way that's effective, and so we need to put together an effective prosecution team. It'll include some members of the House, but they ought to hire actual practicing lawyers who know how to cross-examine witnesses. And the team should also include people who are really good at public speaking and who are people who can appeal to, well, not Democrats, right? Who aren't just preaching to the choir. And so it ought to include Republicans. They don't have to be members of the House, right? Think of prominent Republicans who can say the same words a Democrat would say, but coming from a Republican, Republicans are going to be more inclined to accept them. So I don't know, one example that occurs to me is Jeff Flake, right? He strikes me as a perfect person. to make opening and closing statements in a prosecution of Donald Trump, right? The only downside to that would be it would also mark him as the certain Republican candidate, and I don't know if the Democrats could beat him if he ran for president, having brought down Donald Trump in an impeachment. So he might be too good to occupy that role. Okay, so then the next thing that happens is a trial proceeds in the Senate. The articles are carried over by the House managers, and unlike the House of Representatives, the Senate has extensive rules of procedure on the books for the conduct of an impeachment trial. When House managers present articles of impeachment to the bar of the Senate is required to hold a trial. This is why Mitch McConnell has not promised that he would do to this what he did to Merrick Garland's nomination for the Supreme Court. It's because under the rules of the Senate, he can't. Okay. Now, you could try to change the rules of the Senate, but since this isn't the first day of the Senate's session, that will require a 2/3 vote, and that won't happen, right? And he knows that won't happen. So he knows he has to hold a trial, right? There will be a trial, right? So what's it going to look like? Well, because it's a trial of the president, the Chief Justice will preside, right? And so if you think back to Bill Clinton's impeachment trial, you'll remember probably the most colorful part of the trial was William Rehnquist with the emperor had literally new clothes, right? They were actual clothes, his robes with the gold stripes on the sleeves, right? I think that was the most interesting part of Bill Clinton's impeachment trial. So we'll see, maybe John Roberts will wear a red robe, I don't know. The fashion possibilities are endless, right? Okay, so John Roberts will preside over the trial, and the other best part of the trial is the rule that says members of the Senate must remain silent during the trial. They have to sit there like potted plants and listen. They cannot speak, which talk about something cutting against every fiber of a legislator's being. Right now, they can leave the chamber and go out and in the halls, start talking to the banks of cameras that will be there enrolling, and I'm sure they will do that extensively. But while they're in the Senate chamber, they cannot speak during the trial, right? Instead, what happens is the president has counsel, and the House managers and whatever counsel they bring along act as the litigants. Right? And they call witnesses, they present evidence, they make motions, the Chief Justice rules on the motions, and here's where mischief can come in. The Chief Justice's rulings can then be appealed to the Senate, okay? And then the Senate votes. So it's not difficult to imagine that in the first 5 minutes, the President's counsel stands up and says, I make a motion to dismiss. Right? At that point, Chief Justice Roberts, I think, would deny the motion because why does he want to get in the middle of that? And then it gets appealed to the Senate. And at that moment, the full Senate could vote to grant the motion to dismiss, and the trial would be over. Right? That's at least a conceivable possibility. Which is why it's so fundamentally important that the proceedings in the House be perceived as above mere partisan ambitions, right? Partisanship will be part of it, inevitably. But if what comes out of the House is not understood as merely sort of the Democrats' partisan vendetta against Donald Trump, but is perceived by a broad segment of the public as genuine allegations of serious wrongdoing, then that motion to dismiss becomes politically untenable for Republicans in the Senate to approve, and that is the thing that would prevent them from doing that. It's the only thing, right? It's the only thing that would prevent them from doing that. So again, it's that 2/3 requirement which imposes a requirement of bipartisanship that suffuses every moment of an impeachment proceeding. All right, well, I've got a bunch of other things to say, but I would run into my 501c3 thing. So instead, let's just start our roundtable, right? So there's the process. Oh, no, there's one last part of the Senate's procedure. If the Senate actually conducts a full trial, Then at the end of the trial, the Senate has to deliberate and decide how to vote. Those deliberations under the rules of the Senate are held in secret, right? Everyone but senators is kicked out of the Senate chambers, the doors are closed, and they deliberate, right? And those closed-door deliberations are no holds barred, right? They say whatever they say. I know during the Clinton impeachment, it was clear that the articles of impeachment that had been brought against Clinton were not going to be approved. And so at that point, Republican senators started bringing up other matters, like, now we've all heard of Juanita Broaddrick and her allegations against Bill Clinton. Those were raised for the first time in that closed-door session, right? Before, they weren't brought before the Senate during the trial. They were never brought. At that point, anything can happen, right? And it has happened in that case because it had never been litigated. The Senate decided not to proceed on that ground, right? So they held their deliberations, and then they leave, they end their deliberations, they go back to their seats, the Chief Justice comes back in, and there's a roll call vote, right? Because the requirement in the Constitution that senators be on oath or affirmation, that requires a public vote. And during the vote, the rules provide that the Chief Justice the presiding officer, in this case the Chief Justice, call the roll, and the only thing a senator is allowed to say is guilty or not guilty. And at this point, you might remember the spectacle of Arlen Specter trying to say not proven, right? And Chief Justice Rehnquist telling him he has to say guilty or not guilty. He can't say not proven. That's not an option. And eventually his vote was recorded as not guilty. So then they take that vote. That's significant too because it's a public vote, right? I've heard countless times from Republican Senate staffers that if there were a secret ballot, you would have 90 votes to convict Donald Trump tomorrow, right? But because it's not a secret ballot, they're all afraid of being primaried, right? And so if they vote to convict Donald Trump, they're going to get a primary challenger. The only way to overcome that fear is for them to hold a countervailing fear. And the countervailing fear would be that the charges against Donald Trump are so overwhelmingly accepted that allowing him to remain in office will pull down the whole Republican Party. Right? That's the fear that has to be established on the other side. If it is, then Republican senators can be open to the idea of voting to convict on impeachment, which again just points back to that 2/3 requirement and the way this whole thing needs to be handled from start to finish, which is to say it needs to be aimed at that bipartisan group. It needs to be aimed at fundamental commitments of American constitutionalism that are subscribed to, adhered to, that we're devoted to, whether we're Democrats, Republicans, it's part of being American. That's how the impeachment articles need to go forward or need to be developed and then brought forward. If they are, they might succeed. All right, now I'll go roundtable. Yeah, Katie?
Whether they would faithfully apply the precedent from the Watergate tapes to the president's sweeping immunity and privilege arguments that are being put forward?
So, Brett Kavanaugh has said he thinks U.S. versus Nixon was wrongly decided, right? So I'm not confident he would faithfully apply that precedent. So, no, I'm not. I'm not at all confident of that. Yep.
Question on timing. So the Republican talking points last week were the Democrats had to vote. And clearly there's no procedure at this point that would require the Democrats to go on record as to who supports this inquiry. So they declined to do that, and I think that makes sense. But you also have, in parallel, McConnell saying, okay, we're going to have to go forward with this, but he's already dictated the timing of this, saying that the So do you have any sense of the timing from what you're seeing? It seems like we should not wait. I know you have tax concerns, but we the people. It seems like the longer the investigation takes place, the more people become socialized to this issue.
Yeah, so Mitch McConnell has no control over timing, right? He can't hold an impeachment trial unless articles of impeachment have been brought to the bar by House managers. Otherwise, there's no impeachment to try.
But even once it gets going, Roberts has some say in how this goes and what evidence can be heard and what witnesses can be heard. That's all going to be challenged.
Yeah, so, right. So with respect to timing, right, just the timing part of it is a tricky issue for everybody. Okay, so it's a tricky issue for Democrats because the argument against impeachment will become a process argument rather than a substance argument. And the process argument will be, well, there's an election scheduled in a year, let's just let the American people decide, right? And the American people elected Donald Trump 3 years ago, and why should you, now that you have a majority in the House, go undoing what the American people did 3 years ago and will have an opportunity to do again in a year. Let them decide, right? And the closer we get to the election itself, the more powerful that process argument becomes. Okay? Now, I think there are a number of responses to that. First of all, the American people never elected Donald Trump. The Electoral College chose Donald Trump against the will of the American people, right? So that's the first point, is there was no democratic will involved in Donald Trump becoming president in the first place. In the second place, the whole predicate for impeachment is not to punish someone for something they did, right? That's the job of the criminal law. And the Constitution provides that impeachment does not preempt criminal punishment. Okay? So the idea of impeachment is this particular individual is harming the republic and should not be allowed to remain in office, right? That's the general principle. Very specifically with respect to Donald Trump, we've seen in the last week what, in 1 week, the harm Donald Trump can do to the nation's standing in the world, to our foreign policy, right? 1 week. We should not have to tolerate 52 more weeks of that, right? Or if we're into February, I don't know, what is that, 40-some more weeks, 40-some more weeks. 3 more weeks of it, if it were 3 weeks before the election, would be intolerable, right? So you're definitely going to hear those kinds of timing arguments. And you're going to hear those, well, it's anti-democratic arguments, okay? And I don't think those arguments are at all persuasive, or they shouldn't be, if the predicate is met, right? If it is actually the case that Donald Trump has engaged in the kind of misconduct that represents a high crime and misdemeanor, right? Then I think we have no problem from the standpoint of timing, no problem from the standpoint of principles of democracy in proceeding with a trial and a conviction. Yeah.
So you said earlier that in order for impeachment to be effective, you need to have the 2/3 removal vote in the Senate. I've heard some talk elsewhere that the founders had intended impeachment to be a chastening device in and of itself, so that under that reading of the Constitution, the House has a duty to impeach regardless of whether the Senate will convict or not. I think you think that's wrong. Tell me why.
Well, so I don't think there's much of any actual evidence that that's what the framers thought, right? The framers thought we need to have a mechanism for removing officers who are a threat to the public. Right? And so then the framers, if you go back and read Madison's notes from the convention, you see they went through various formulations to try to come up with a mechanism that would do that, but that would be faithful to the sort of general separation of powers principle that the branches should be distinct from one another, that the president should not be the subordinate of the legislature, right? So the initial draft said the that civil officers, including the president, should be removed upon impeachment for maladministration, right? And the convention at Madison's urging thought that maladministration was too vague a term and that it would amount to the president serving at the pleasure of the Senate, right? So the idea was to keep the president independent from the Senate. And so impeachment shouldn't be something that was chastening. That was not the idea of impeachment. The idea of impeachment was that it should be a mechanism for actually removing officers who had done harmful things. Congress has at its disposal various methods of censure, including censure, right? That's a way of chastening. Okay? Impeachment is something more and different than that. The House actually debated exactly that point during the Clinton impeachment and determined not to even give the House of Representatives the option to censure Bill Clinton because Newt Gingrich knew that that's what the House of Representatives would do, right, instead of impeaching, and he wanted to force them into an all-or-nothing decision. Right? Censure is there for chastening if that's what you want to do. Impeachment is designed to be the method to remove someone whose continuance in office is harmful. Yeah, Erica.
So I understand the president traditionally has a private attorney during the impeachment process. During the Clinton administration, what were the roles of the Department of Justice and the White House counsel's office in impeachment? And before that, I don't know if the White House counsel's office was around during the Nixon administration, but what were the roles of those two
The White House
offices?
counsel's office was around. It was headed by John Dean.
All right, okay, thank you, apologies.
So they were kind of involved.
Fair enough.
Material, right, the advocate witness rule. I don't know if you remember, during Clinton's impeachment trial, I think probably the most effective advocate for Bill Clinton was Cheryl Mills, who was his White House counsel at the time. Her arguments were just beautiful, just really admirable pieces of advocacy that, if you just want to study advocacy, you could do a lot worse than going back and watching Cheryl Mills's addresses on behalf of the president. So the White House counsel can be involved. I don't recall the Justice Department really being involved at all. But there's nothing that prohibits that, right? And so I would expect in an impeachment trial of Donald Trump, I just can't imagine Bill Barr sitting it out, right? And I don't think there's anything that would require him to sit it out. So I think we would see him, and I'll just say he's no Cheryl Mills. Yeah, Jill. I thought the run was this morning at 7, but it turns out it's.
I confess I don't remember this from the Clinton impeachment. Was he present, or was he just like in the White House going about his business?
He was not present.
Interesting.
Yeah, he was in the White House going about his business of watching it on television, right?
So as obvious as it seems that it would be an abuse of power for the president to pardon himself on his way out of office, what legal checks would there be to stop him? Could he do that? And then even if a future administration sought to indict him, seek to move that indictment on the grounds that he'd self-pardoned or anything like that?
So if the president self-pardons, the way that gets into court is someone prosecutes him, and then the first question is, was the pardon valid, right? And I don't know the answer to that question. The Justice Department's position on that is that self-pardons are invalid, but that position was taken during the whole Watergate process, but it's expressed in, I think, maybe 3 sentences in an opinion dealing with something else. It's not a very powerful argument, right? It's only 3 sentences long. it says in very conclusory fashion that self-pardon is inconsistent with the idea of the rule of law. And so on we go. And I get, it's an argument, right? I mean, in terms of originalism, I wish Eric were here to talk some about originalism. This strikes me as it's the kind of question that shows originalism to be bankrupt, right? Because what was the practice at the time? Well, the practice at the time, the executive that we knew before the founding of our nation was the king, and the king could not pardon himself. But the king couldn't pardon himself because the king was above the law and couldn't be tried or convicted anyway. So what does that tell you? It tells you nothing that's useful to our system because we have a different system, right? What did the framers think about this question? They didn't think about this question, right? So if you go back and you read original era history, you read Madison's notes, you read the ratifying convention, you read the Federalist Papers, you do see over and over again this idea that the president should not be above the law, right? And that brings you back to the conclusion of the Justice Department, which is pretty much just an unadorned conclusion, that it's hard to square the idea of a self-pardon with these sort of constitutional commitments, these background penumbras and principles that are the thing that actually guide how we understand the Constitution. Now, there are originalists who make arguments to the contrary. Sai Prakash, who's a law professor at the University of Virginia, has written a book called Imperial from the Beginning, where he argues that actually the president is a king, and then he goes through and he answers like 150 questions of presidential power based on his original understanding of the president as king, and one of it, he devotes 2 pages to the question of self-pardons and concludes that they are permissible. So there you go. I don't know the answer to the question. I would come down on the it's not permissible side because of the rule of law commitments, but I don't know what the correct answer to the question is because we have to shake the magic 8 ball that is the Supreme Court, and the answer will appear when we do.
Okay. Kind of going with the rule of law, something that I've kind of been thinking about lately is how the oath of office, which, may just be considered a, just performance, but how things like oaths of office may have a contractual nature, how when you take the oath of office, it's almost, in any way, it creates a waiver to that sort of notion that you would be above the law. When you say that you will faithfully seek to enforce the law, if that doesn't, and it's sort of been swirling around in my brain, so it's not complete, but like, do you see any sort of component to that being relevant to, because that has to mean something. It can't just be perfunctory.
Right. So we talked a little bit about this on the rule of law panel yesterday. Erica actually brought up the take care clause, which people who work where we used to work, the Office of Legal Counsel, tend to read as kind of a necessary and proper clause for the president. It's a way of the president having incidental powers. That is not, in fact, what the take care clause is. The take care clause, right, the take care clause is a clause that says the president shall take care that the laws be faithfully executed. The reason that clause is in the Constitution is to impose upon the president the duty to follow the law. Right? The king could dispense with the execution of the laws, and the take care clause performs the function of making it clear that the president cannot dispense with the execution of the laws, that the president must take care to faithfully execute the laws, whether he agrees with them or not. Okay. That is a textual commitment to this idea that the president is subject to law, not above the law, right? And that sort of is one of the ways we know that our Constitution embodies rule of law commitments. From that, we can, as you're suggesting, reason to this conclusion that self-pardons are inconsistent with that. So, yes, I would say take care clause, and don't forget about the take care clause and the function it's supposed to perform, which is a constraining, not an empowering function. On the other hand, I would say the predicate for a self-pardon is the prosecution of a former president, and we talked a little bit about this yesterday too, but I think it's a really dicey thing for a new administration to come in and prosecute the outgoing president, right? And we could say, well, this is a special case, but next time around, it's going to be a special case, and it's the kind of thing that can make it a crime to be a member of the wrong political party, right? And so I think it's a very dangerous road to go down to prosecute a former president, right? It's a way in which I think Gerald Ford's difficult decision about pardoning Richard Nixon may well have been the right one.
Just a really quick question. I'm not sure if this is on. Okay. Let's say President Trump is pardoned, like state, everything, he's clean bill of health. The following week, he commits another crime. I don't think it's a stretch to see him doing that.
You think he'd wait that long? Sorry, 501c3?
Do you think at that point it's inappropriate to prosecute a former president? I wonder, because I think we're going to have that problem.
So, I'm sorry, to prosecute a former president for crimes committed after leaving office?
Yes.
Oh, that's not a problem.
You don't think, but I mean, you don't think that'll be seen as political, just as political as it would have been seen while he was in office?
Yeah, I just think that then we've got a bright line, right? And when I don't know, Marianne Williamson ceases to be president, that, no one's going to go after her, I wouldn't think, because you've got this bright line distinction that crime was committed after you left office, right? To me, the real danger to our democratic norms is prosecution for something you did during or before your time as president. Okay, I just got a card that says stop, so that's what we're going to do. That's right. Stop me before you lose your 501c3 status, right?
All right, so we learned about 501c3 and so much more. Again, everybody, I think I met almost everybody here, if not everybody. I'm Zanelle October, interim president of the American Constitution Society, and I want to formally thank all of you for taking the time to join us these last few days. We know how very busy you all are, and we're so grateful that you joined us to strategize, recharge for the lots of work that we heard is ahead. Thank you to ACS staff. May ACS staff stand so we could give them a real big. Thank you all. And I want to include among those staff, she couldn't be with us this weekend, our colleague Michelle Hurd. She was really instrumental in organizing this convening with the rest of the team, but has been thrown a little curveball health-wise, which prevented her from joining us in person. But we want to acknowledge all the work that she put into this and her being an amazing colleague always. So to Michelle also. To our speakers, what an impressive and powerful group of advocates and leaders. Thank you all for coming and sharing all of your good information with us. We've gotten our charges from you. We will move ahead with all the work that you have put before us, and we thank you for everything that you do in your communities every single day. I also want to, you don't have to clap to everything. We'll do it all in the end. Thank you to our volunteers, who included some of our law student leaders, as well as some Spelman and Morehouse undergrads who we particularly wanted to have here, so that they could learn from you, network with you, and be inspired, because they are our future, and we want them to be included in the future as our legal professionals too. So thank you that they were here and volunteered with us. And last but not least, thank you to our Georgia Lawyer chapter for their enthusiasm in hosting us. We have definitely felt the Southern hospitality, so thank you so much for having us here. We covered a lot these past couple of days. We were briefed on the challenges that confront us here in Georgia and across the country. We heard from advocates who are on the front lines of a lot of this work in civil rights and voting rights. We heard about the rollbacks there. We were briefed on the inequities of the right to counsel and the need for counsel. We were briefed on the importance of an accurate census count, and I hope everybody will get involved in that effort too. We were briefed on the challenges that face us as a nation: the rule of law, our norms, our institutions, our democracy are all under threat. We know the work that's ahead. Many of us are already working on it. Many of you are working on it. We're so inspired by what you're doing. We learned how lawyers are fighting back and leading the path forward. We learned how lawyers are thinking creatively and affirmatively to pave the path for progress, even in the face of today's many, many, many challenges. We saw leaders collaborate, form coalitions, lift up other advocates' work. I hope that you were inspired. I definitely feel inspired. I feel wowed by this entire weekend. Inspired to do great, powerful work. Inspired to focus on your communities, your cities, your states, and start advancing progressive causes locally. Inspired to protect our judiciary. It's at the heart of a lot of what we do. Inspired to protect our elections. Inspired to combat extremist thought on the right. Inspired to run. Inspired to explore that path to the bench. I am talking to all of you. Inspired and equipped. We had a great leadership training that set the way for us to this, to lead. We are the leaders. We are the ones who are going to save this democracy. We need each of you. And look, you're all working on a lot of these issues already, and we've got some new charges on other things that we need to work on. We're all tired. I'm tired too, but our democracy relies on it. You know, a group of us, I know we had a couple of amazing outings to kick off the weekend. I was included in the group that went to the MLK birth home. That was so inspiring, and it reminds you of the work and the work that came before you and the work that's ahead of us and all that we have to do. Many people are tired, but we've got to do it. The moment is ours. The moment is calling on each of us to do more. So recharge, come for the weekend, re-energize, take time to get to know each other. This was wonderful, but we have our charges ahead as we go back to our communities, and I really thank you all for that. We saw the power of the network. ACS is awesome. Join us as a member if you're not already. Join your local chapter if you're not already involved, or help us start one there. Reach out to us. We'd love to do that. Keep in touch with your new ACS besties. They're all around you. I've seen this camaraderie. It's been awesome. Most of your connections, because they will be your champions. We need to support each other in this work. It's not easy. It's exhausting. It is daily. So we all have to support each other in that. David Dryas shared his story with us on Thursday evening of working with members of the ACS network to ban the incarceration of pregnant women in Georgia. From our conversations with you at this convening, we know you have ideas and strategies for the network too. Share them all. The national office does not have them all. We don't. We need you. You are the ones who we rely on to tell us what's happening in the communities and how we could support you. Our network has stepped up on so many of these issues it's been a really good feeling. It's what keeps me in this work for sure. I've been at ACS for almost 9 years. And, you know, these past 2.5 have been some of the hardest for sure. But I'm so inspired by the network and seeing all that you do in your communities that of course we all have to keep going. It's not even a question. You all have a Post-it in front of you by now. You should. Take a moment to write down a goal or a strategy idea that you want to work on as a result of this convening this weekend. If you write your name down, our chapters team will follow up in 6 months to see if you're closer to meeting that goal or advancing that strategy. You're not required to write your name down, but if you'd like to, we're happy to hold you accountable. Make sure you fill out the survey to let us know how we did. There's always room for improvement, so we want to hear from you. And we can't wait to see you all again in the future at ACS events in your local communities or our national events. A couple of opportunities, as you heard about some of the Supreme Court work, if you're interested in being part of the Supreme Court bar, we have a group swearing in Washington, D.C. We'd love for many of you to join us. That's April 6, 2020. There'll be some materials that you have to fill out to let us know that you're interested, but we'd love to see you there. If not then, or in addition to then, our national convention, we all convene. This has been our lawyer convening, but we have an amazing group of law students, judges, scholars, the whole network, some who couldn't be here, some who are here, who are going to be there, June 11th to the 13th in Washington, D.C. We hope you all join us. Make your plans now to join us. We'd love to have you. We'll continue many of these discussions and strategize, energize. We'll need another opportunity to re-energize, I'm sure, so it'll be there. But thank you all again for your support and for being here. We look forward to seeing you soon. Have a safe trip home, and thank you.